see if it's on or not. You just have to guess.
And so we're just redoing this revocation judgment, right?
Yes.
Okay.
We're in session in cause number 321-974 and cause number 329-889. Both cases are styled the state of Texas versus Jarvis Allen Josephs. Let me repeat that. The case is styled the state of Texas versus Jarvis Allen Jacobs. We have Mr. Jacobs appearing via Zoom. Mr. Jacobs, would you please raise your right hand? Mr. Jacobs, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Okay, Mr. Jacobs, you may put your hand down. Mr. Jacobs, how are you doing?
I'm good. How you doing, Judge?
I'm doing fine. Thanks for asking. Mr. Jacobs, you're represented in your case by your attorney, Mr. Ryan Matuska. Mr. Matuska is also appearing via Zoom. Mr. Matuska, how are you doing?
Good afternoon, Judge.
Good afternoon. Now, Mr. Jacobs and Mr. Matuska, prior to us doing this plea, we started this plea earlier, and the court noted that Mr. Jacobs' charge was that he was on probation for was criminal mischief, family violence. And the court noted that that wasn't an offense because in the code, on the penal code, section 28.03, it doesn't have a family violence provision. And plus, in article 42.013, for a family violence finding by the court, it has to be a Title V offense, and criminal mischief is not a Title V offense. It is a Title VII offense. And so after looking at the case, I know that the court stated that it still had jurisdiction and it can do a non-proton. And Mr. Matuska, you stated that you probably can do a writ. Is that correct?
Yes, I believe that would be one remedy.
That was one remedy. And so after looking at the judgment and obviously looking at the information, the court is finding that the word family violence is just surplusage in the information because it does not enhance the punishment in Mr. Jacobs' case. And when the case was reported, it was reported as a criminal mischief. And so the court is of the opinion that it was a clerical error that when the case was taken in through intake, it was mistakenly, that language was, as a mistake, was added on. And so that same language as a mistake was added on in the judgment. So therefore, the court is believed that it can do a non-proton, and the language in this case is surplusage. Mr. Matuska, do you have any objections with the court going forward with that statement?
No, sir.
Okay, now, Mr. Jacobs.
Yes, sir.
To this, okay, prior to going, okay, we have a motion to revoke your probation in cause number 321-974. And you just heard the statements that have been made to your attorney. And Mr. Jacobs, do you waive any objections to the court going forward with this case?
No, sir, I just have one question. What does knock means?
A non-protunct is a correction in the judgment.
Okay, yes, sir.
Okay, so if there's some kind of, if an error was made, we correct that error. There's usually what we call a clerical error. So some clerk who inputted it made a mistake and put that language in the charging instrument as well as in the judgment. Do
Yes,
you
sir.
understand that?
Yes,
Okay.
sir.
Now, if you need some time to talk to your attorney, we could give you time to do that.
I have one more question. I can ask you.
No, well, you probably, let me do this here. I'm gonna give you